Randy Zelin, now with us, criminal defense attorney, former prosecutor, adjunct professor at Cornell University Law School. I told you this guy was good with law. So, Randy, it's an under and over thing with you, so apologize for my being so simplistic. How long do you think this jury deliberates?
I think the jury deliberates for a good 7 days.
Wow.
And I think they come back and tell the judge that they are unable to reach a unanimous verdict. And even after the judge instructs them and says, hey, come on, there's no better jury out there on this planet that could do it. So let's get it done. I think they still come back and say, Your Honor, we cannot agree unanimously. And at that point, the judge will declare a mistrial because of a hung jury.
All right, so that is his option. If the jury cannot agree unanimously on either a conviction or an acquittal, then the judge would have to, at that point, say it's a mistrial. Then what?
Yes, what will happen is first the judge gives what we've all heard, the legal community, we live it, but for the lay people, something called an Allen charge, based upon an old United States Supreme Court case, which basically gives the judge the opportunity to bring the jury out and say, look, come on. I know you're at an impasse. I'm not asking you to do violence to your own individual consciences, but I have no reason to think that there's any jury that could do it better than you. We've been here. We've been doing this. Come on. Go back there, talk, listen to each other, keep an open mind, and try to come to a unanimous verdict. And then at that point, if they can't, then the judge declares a mistrial, and there will be a do-over. And then, of course, the $64 question will be, does that do-over take place before this judge? And does that do-over take place before the election?
All right. Now, I'm just looking at the sheer number of counts here, 34 counts. So the idea that the former president can dodge a conviction on all 34, I guess it's obviously statistically possible. I'm just wondering how you look at that, the sheer number of those charges and getting off at least, you know, with a full jury saying otherwise.
Well, I will borrow a new word that I think the former president came up with and should get credit for in the dictionary, which is confliction. I am conflicted here. What was lost on me until this morning was the fact that no one has ever really spoken about a compromise verdict, a Solomon-like verdict, where the jury, and oftentimes we see this in other trials, there are a number of counts and the jury's like, you know, I want to throw the defendant a bone, but by the same token, I do think he's guilty, so I'll tell you what. There are 6 counts here. We find him guilty of 2. We find him guilty of 3. We'll split the baby. Here, that's a more difficult thing because this really is one deal. It's one transaction. It's 34 counts, but it really arises out of one thing. Whether or not the former president knew that false entries were being made in his books and records, and they're all the same false entries, which are these payments to Michael Cohen. So it's not like one payment was for Michael Cohen. Okay, so was that a legal fee or was that a hush money payment? And here's a payment to Best Buy. Was that for a TV in the office or was that for a TV at home where you can kind of mix and match? It really is, you either find him guilty on all 34, because all 34 relate to Michael Cohen, and then the elevation of the misdemeanor to a felony based upon this tax fraud or election law fraud. I don't know that you can parse him out, but there's nothing preventing the jury from doing just that and saying, let's find him guilty on some.
All right, so let's say that, I didn't mind you jumping you, my friend, but let's say they convict him on something. Then it becomes up to Judge Merchan, right, who would then, I guess, talk to the prosecution and defense in a pre-sentencing sort of a meeting, a pre-report, if you will. But I cannot imagine him, you know, throwing him in jail in that, or if it came to that. There's probation, talk of that. That, too, seems a little unusual. How do you see that playing out if there's a conviction?
If there is a conviction, and let me start out by talking about one of the really nice differences between state practice and federal practice. In federal practice, 34 counts, you could run the table and be acquitted on 33 and convicted of 1. And under federal law, the judge can still consider those 33 acquitted counts if, in fact, the judge finds that there was a preponderance of the evidence to show that you did it. It's a horrible law, and it's a horrible way of doing things. You don't have that in state practice. So if the former president runs the table on 33 of the 34, he only gets sentenced based upon that one count. Now, this is a white-collar, first-time offender. This is really a victimless crime unless you say that the entire country was victimized by the election being stolen from Hillary Clinton. He's not going to jail. He is not a candidate for probation. If he were to be convicted, he will be given an unsupervised probation called a conditional discharge, and he would be fined.
All right. We'll see what happens. We're a long way from that. Maybe not, depending on, I know your time frame is 7 days of meetings here. So we'll see what comes of that. Randy, always learn a lot. Thank you very much.